Joe.
Good afternoon. May it please the court, my name is Steve Kurens. I represent the appellants, two young boys from the Betancourt family, one aged 2 who suffered catastrophic burn injuries and one aged 3 who died as a result of using a non-childproof defective cigarette lighter that was supplied by the defendants. The trial court dismissed the plaintiff's negligence and strict liability claims on preliminary objections. And the plaintiffs will explain to the court today why those holdings were error of law and should be reversed. Before I do, I would like to reserve 2 minutes for rebuttal, if I may. The trial court committed 2 errors, which I'm going to discuss with you today. Number 1, the trial court erred in holding that a plaintiff in a negligence case involving a product has to prove the existence of a defect as defined under strict liability law.
Does that mean a reversal of Dambacher?
I'm sorry, Your Honor.
Does that mean a reversal of Dambacher from 1984?
No, it does not, and that's a key point because the trial court relies on Dambacher. Dambacher's statement that plaintiff in a negligence case must prove the existence of a defect, number 1, was dicta. The plaintiff had not brought a negligence case in that case, and it was tried, as the court knows, solely on strict liability. Second, if one looks at the holding carefully, it's clear that what the court is after is it is not using defect as a term of art to mean defect as defined under strict liability law, and indeed looking at the derivation of the 2 theories historically, that would not make sense. But the court is using the term defect to mean did the product expose the plaintiff to an unreasonable risk of harm.
They're using strict liability terms, and now they're being applied. The problem is they're applying them to negligence issues.
That's correct, Your Honor. And the problem, and this has been a source, I believe, of some confusion before the courts of Pennsylvania, that case has been subsequently cited with approval, as pointed out by the appellees, particularly in the O'Neill case and in the Fitzpatrick case. In both of those cases as well, the issue was dicta. The reliance on Dambacher was dicta in that, for example, in O'Neill, there was no record before the Superior Court because the plaintiff had not responded to a summary judgment motion. And there was no evidence in any direction showing whether the product exposed the plaintiff to an unreasonable risk of harm. In the Fitzpatrick case, which involved a motor, or propeller, I should say, on a motorboat, the court actually wound up doing what we say to the court today it must do as part of a common law negligence analysis as to duty, and that is it found that a motorboat propeller could not be made safer. There were no other ways of changing the design of the motor so that the motor would continue to work. And that analysis is the analysis that we feel should apply here. And it is basically a risk-utility analysis which the courts of this state have applied for 100 years as part of the negligence analysis. Specifically, as I've said, the standard is, did the defendant expose the plaintiff to an unreasonable risk of harm, and was that unreasonable? Was that foreseeable? Was the harm foreseeable? It is indisputable in this case because the defendant has admitted it for the purposes of this motion that harm to young children was foreseeable, that children were going out in large numbers and using cigarette lighters and sustaining death, sustaining serious injury. And the defendant knew that. The defendant has also admitted that alternative designs were feasible and were available at the time of this accident. The reason why I say that's indisputable is that 6 months after Alonzo Betancourt died, the federal court enacted regulations which required that all cigarette lighters in the United States be sold with child-proofing devices. In other words, the federal government made a risk-utility decision that the limited utility of these non-child-proof cigarette lighters was greatly outweighed by the grave risk of harm posed to these young children who were foreseeably using these lighters again and again and causing very significant damages to themselves and others. The federal government's risk conclusion after making its own risk-utility analysis is exactly the conclusion that the trial court here should have reached. That is that weighing the foreseeability of harm, weighing the gravity of the risk, weighing the limited utility of the product without childproofing, given the fact that safer alternatives were not only known, were not only foreseeable, were not only available, but were known to the defendants, that this was a breach of this supplier's duty of care in continuing to market and in continuing to sell non-childproof lighters to young children. By holding, in effect, that the Betancourts were required to prove that this lighter was defective as defined under strict liability, and that is what, in effect, the trial court did. As part of proving its negligence case, the trial court created a new burden of proof for plaintiffs in negligence cases, and in the process ignored evidence that's cited in Griggs, and that the court may take judicial notice of under the federal study, that in fact defendants, large suppliers like this defendant, not only could have foreseen the risk of harm, but in fact did know about the risk of harm posed by this product. This is a product...
Instead of a lighter, a mechanical lighter, they were ordinary kitchen matches.
I'm sorry, Your Honor, I couldn't hear you.
They were ordinary kitchen matches.
Ordinary kitchen matches, for example, matches used to be made so that you could strike them on anything and you could light them readily. That is no longer the case. What happens now is a child has to, or a person has to take a match and strike it against another object. That was done specifically because the risk of harm to children was known. The fact is in a situation like this, a 2-year-old or a 3-year-old doesn't have the dexterity to take a match and to light it on the run.
It requires none at all.
I'm sorry?
It requires no dexterity at all.
No, it does require manual dexterity, Your Honor, in order to...
Strike something?
Sure. For a 2-year-old or a 3-year-old, it does. And this is not a match. This is a lighter that is sold widely throughout the country. It is marketed for convenience, to be carried everywhere. It's marketed to be attractive.
What about an ordinary kitchen knife?
An ordinary kitchen knife is an entirely different setting because a knife cannot be made more safely. A knife can only work if it is sharp and if it has an exposed edge. That is not the case here. As the federal government mandated, these lighters are not unavoidably dangerous, and in fact, they can only be bought today with childproofing.
And what about childproofing, mostly kitchen, I guess, scrubbing things and everything? Isn't that childproofing there, a lot of it?
Are you referring to, for example, cleaners or some sort of toxic substances, which are commonly childproofed, as are aspirins and medications,
Are they required,
et cetera?
do you know, to be childproof?
Yes, they are. Under federal law, there is packaging and labeling requirements as well as childproofing requirements, to my knowledge, and that is part and parcel of a defendant's duty. Here, though, a duty may arise regardless of a specific regulation. That has always been negligence law in Pennsylvania. A defendant cannot be held liable or cannot be held to have a duty solely if there is a regulation in place which tells them, thou must do this. The duty arises from their conduct. Did their conduct create a foreseeable risk of harm? Here, the pleadings show, and the record evidence shows clearly that their conduct did create a foreseeable risk of harm. I would like to move on to the strict liability issue. Our argument is that the trial court committed reversible error by holding that the plaintiff could not establish a defect because he was not an intended user as a matter of law. By using this test, which was an improper test, the trial court essentially used the defendant's own unsupported subjective intent to determine whether a young child was an intended user. That is not the law of Pennsylvania. The trial court, in coming up with this test, relied on Griggs, which also involved a cigarette lighter. And in that case, the Third Circuit held that in Pennsylvania courts, in weighing as a threshold matter whether a product could be found strictly liable by a jury, did not use the risk-utility analysis that has been called for under Azzarello and has been called for under subsequent Superior Court cases. The Griggs opinion, the Griggs holding in that regard, and because it found that Pennsylvania courts would not apply a risk-utility analysis, but instead would simply look to the question of whether a plaintiff was an intended user as a matter of law, that portion of its holding was specifically disapproved by the same court in 1997 in the case of Sheetz versus Caterpillar, where the court said excuse me, to the extent that Griggs can be interpreted to read that a trial court does not do a risk-utility analysis as part of its threshold determination, that is overruled. That case is no longer good law in the circuit that held it.
Well, were they referring specifically to Pennsylvania law in that case?
Yes, they were, Your Honor. Yes, they were. Now,
I thought that was the problem in Pennsylvania as well, is that we have not applied a risk-utility analysis in products liability cases.
well, no, that's I guess the key point. There has been some confusion on that issue. But for example, this court in Riley clearly held that in weighing a determination making the threshold determination under Azzarello, the court has to do the risk-utility analysis and look at the associated factors, either authored by Dean Wade or that were set forth by the California Supreme Court in Barker. And the Riley court did that risk-utility analysis. And the courts...
Is the Raleigh case the one that came down on intended user and threw it out for that reason?
Well, I was going to get to that, Your Honor. The Riley case did also discuss that issue. And that's been a source of confusion as well. What the Riley case said was, first, doing the threshold analysis, looking at all of the Wade factors, that as a matter of law, that product, an agricultural product, could not be found defective under those factors, including most particularly the foreseeability of harm to that plaintiff. And the court, while eschewing later on the issue of foreseeability and saying under Griggs that foreseeability was not an issue, in fact, the court did look as part of the Wade factors as to whether the risk of harm was foreseeable and quoted the plaintiff's expert as saying candidly, there have been no incidents such as this, and it is not foreseeable that a young child will simply stick his or her hand into the rotating blades of a product.
Beyond the Raleigh case, beyond the Raleigh case, have there been other, I'm not disagreeing that risk-utility isn't a better way to go, perhaps. All I'm saying is I didn't think we were there in Pennsylvania. Beyond Raleigh, are there other cases that you cite in the brief which have used that analysis and adopted it in Pennsylvania?
Yes, Your Honor, there are. There are a number of cases. I believe it's in the Doherty case. I may be wrong, but that is the case involving the firemen who were using a thermostat on a boiler, and unfortunately the boiler exploded. There are a number of cases cited in our brief which uphold the use of the risk-utility analysis, but the Riley case of this court is the most recent.
But I thought that was on the intended user, the Riley case.
Well, what the court said in that case was, here we are, we're going to weigh the Wade factors under the risk-utility balancing test. And they found that the evidence, and again, in this case, the plaintiffs were not given the chance to create evidence because we're on preliminary objections, and we argue that we should at least be given the opportunity to create a record to test the defendant's statement, oh, this is not an intended user, based on all the totality of the circumstances. But the court then went on to say, having found against the plaintiff under the balancing test, we also think that another basis for summary judgment would have been the intended user test, and they then cited to Griggs. And as I said, 4 months later, Griggs was overruled. Griggs was held to not be applying the proper test because it held that the risk-utility test was not part of the court's threshold determination.
You're well into your rebuttal time. You may wish to finish or reserve a minute of it.
I'd like to reserve just a minute of it in that case, Your Honor. I should add that the standard the standard is foreseeability. The courts in strict liability cases, this court, has continuously said that foreseeability is the determination as to what foreseeability of harm to the plaintiff is the question in determining, for example, superseding cause, for determining whether the product was misused. And that's another source of confusion. The court here has said that misuse is a defense, which the defendant must prove, and in proving it, it must establish that the plaintiff's misuse was unforeseeable. And in doing so on summary judgment, it must show that it was unforeseeable as a matter of law.
I thought Riley said that you can't use foreseeability.
Well, Riley, in fact, does use foreseeability, and the court must use foreseeability because that is...
You can't use foreseeability?
No, I think that's been the source of confusion. What the confusion point has been is the courts have been saying the courts cannot instruct juries on the question of foreseeability because that injects principles of negligence. However, the court at the same time has said under Azzarello, in weighing these weight factors, factor number 2 is the issue of, is this product foreseeably dangerous? Therefore, the court's ability to use foreseeability, no weight change, is not limited.
Did I use up all his time?
You did.
Thank
Good afternoon. May it please the court, my name is Miles Kirshner, and I represent the appellees in this action, not the manufacturers, but Novelty Inc., the distributor of, and Sheetz Inc., the retailer of the butane lighter, which is alleged to be the source of the fire which caused the tragic damages to the young boys in the Betancourt family. We do not, of course, dispute the fact that this is a tragic case, but it is not one in which liability can be asserted against the retailer or the distributor. My opponent concluded his argument with the strict liability side of the case, and because I think that that is relatively the simpler side of the case for the members of the court, I'll commence by treating it quickly, if I may. The rule of law which we urge this court to follow is one which is a distillation of Riley versus Warren Manufacturing and Griggs versus Bick. That rule of law is that a product which is safe for use by its intended adult users is not rendered defective by reason of the fact that it might be misused by an unintended child user. There is no question that children are not the intended users of butane lighters. They are marketed for use by adults. There is no intended reason why a child should use a butane lighter. Members of the court, I am supported by a groundswell of both trial court opinions and opinions in other jurisdictions which routinely, at this point, dismiss strict liability causes of actions either in butane lighter cases or in other cases which deal with those products intended for use by adults. I am lucky to have amicus curiae on my side of the case, and they've recently been given leave to file a supplemental brief which will address a few of these cases, but I will just quickly list them for you. On the trial court level in Pennsylvania, following this case was the case of Phillips versus Cricket Lighters, decided by President Judge Fornelli in Mercer County, literally days after I filed my brief in this case. And that trial court opinion has been provided for you in the brief of my amicus curiae. Secondly, at the trial court level on the federal bench, just this past spring and summer, we had decisions from Judge McClure in the Middle District in Shuey, S-H-O-U-E-Y, versus Duckhead Apparel, 49 Federal Supplement 2nd, 413, holding that the strict liability claim against Zippo lighters when a child ignited a non-flame resistant piece of clothing should be dismissed. Similarly, this spring, Judge Kelly from the Eastern District, in an opinion captioned Van Buskirk versus West Penn Company, this was a case that involved a deep fat fryer, and the oil from the deep fat fryer spilled onto a child. That case can be found at 1999 U.S. District Lexus 9130, and the court focused on the intended user analysis of Riley, again, to dismiss that strict liability claim. Jennings versus, those would be the trial court support in this Commonwealth, both on the state bench and the federal bench. There are two other decisions from other jurisdictions which I would reference to you. One will be mentioned in the brief of amicus curiae, which is to come in the next few days. That's Jennings versus Bick, decided in the 11th Circuit on July 22 of this year, and that can be found both in their application for leave to file a supplemental brief, but also at 1999 Westlaw 528211. And lastly, a case decided just 2 weeks ago by the Texas Supreme Court on certified question from the Fifth Circuit, Hernandez versus Tokai Corporation, 1999 Westlaw 645114. All of these cases, members of the court, hold that in those states which apply the consumer expectation test, as Judge Ford Elliott has confirmed that Pennsylvania is one of those states that apply that test routinely dismiss the strict liability side of this case.
Mr. Kirshner, are you saying that all of those cases will be included in the supplemental amicus brief?
I'm not writing that brief, Judge Johnson, but their application spoke of Van Buskirk and Jennings.
Would you ensure that as to those cases which are not in the brief, you will apply for leave to file those cases with us?
I will, Your Honor.
Thank you.
Is that Mr. Long's brief?
Yes, Mr. Long and Mr. Robinson. You actually have the two cases in their application, and they were granted leave by order of the 3rd of this month to file a brief discussing them. And I will file a similar application. Members of the court, I feel that the far more perplexing question here is the negligence side of the case. I am faced with what I call the anomaly of Griggs. I have so strenuously cited Griggs in my brief in support of the dismissal of the strict liability side of the case, yet I must concede that that court permitted the negligence claim to go forward on facts which were virtually identical to this. I respectfully argue, however, that the Griggs court inaccurately predicted what our Supreme Court would do when faced with these facts. I do agree with Judge Joyce that Dambacher is the law. Fitzpatrick and O'Neill, which follow Dambacher, say that in a products liability case based on negligence or sounding in negligence, you must still have proof of product defect. It is, after all, a products liability case. I would like to spend the rest of my argument time, though, by using the case of Pruitt versus Certainteed, which I cited in my brief as a jumping off point. Pruitt versus Certainteed was a case which was distinct on its facts. It was a case where a motorist was leaving a commercial piece of property and was involved in an auto accident. And he felt that the commercial owner of the property should have been able to foresee that accidents would have happened at this place and therefore filed suit on the basis of a duty to warn. Judge Popovich, I have my little cheat sheet here, I know was joined with Judge Weand in that opinion. The court in Pruitt versus Certainteed said some very important things. They said that actionable negligence requires the existence of a duty to act arising either by reason of the actor's creation of an unreasonable risk of foreseeable harm or one judicially imposed because of policy considerations. In my brief, I cited that case for the proposition that the question is not merely whether an event is foreseeable. Rather, the question is whether duty exists to take measures to guard against such an event. And then that portion of the case concludes with the following: whether a duty exists is ultimately a question of fairness. Again, I'd like to take that as a jumping off point.
We already know that the that there was an enactment that made all lighters be childproof.
That's right. And that enactment occurred after the sale of the lighter in this case.
But isn't it a recognition of a duty? Didn't that enactment occur because of recognition of a duty?
No, Your Honor. Respectfully, that enactment created the duty. In another case which is not cited in...
chicken and the egg, right?
Well, in Christensen versus Silfies, a case which I did not cite in my brief, but I now cite it to you as soon as I find it in my notes. This was a case in which the court held that compliance with governmental regulations is relevant evidence to define a duty in a negligence case. Now,
Let me ask this question, Mr. President. Suppose Sheetz and Novel knew that hundreds, if not thousands, of children earn because they get access to these non-child. Suppose they knew that. Would that knowledge support a negligence claim against Sheetz or Novel for selling this product?
I have to thank you, Judge Stoll, for pushing me right into where I wanted to argue. Pruitt said that the question is not merely whether the event is foreseeable, but whether the duty exists to protect against it. Place yourselves, members of the panel, in the...
Let me just follow up on that. Let us suppose that they know this, and now they are selling a product which presents a risk of harm to children. Because of their knowledge, could we not say that they are selling a defective product? and therefore their duty exists to any user since they know children are getting access to it.
You need to place yourself, Judge Del Sol, in that warehouse when that representative of Novelty, Inc. is making the decision whether this box of lighters is to be shipped or not.
I think it's better for me to place myself in that home where this lighter is.
Well, but the conduct which is being analyzed is the conduct of my clients. We're the ones who are accused of negligence. And therefore, Judge, when one is making a decision whether to distribute the lighter or whether to permit it to be placed on the shelves, one can look to the law. One can say, is this something which I'm permitted to do?
I know. I'm the guy in the warehouse, and I say, geez, I know thousands of kids are getting burned with these lighters. Before we can make a nice profit on them, I'm going to ship them because there's no duty. Is that what you're suggesting?
No, Your Honor.
I'm having a little trouble understanding.
I heard a couple of analogies from the bench in the appellant's argument. I thought of another, which is really very current. I have some young children, and we were at Toys R Us this weekend buying child safety seats. And I noticed that the child safety seats, which are being marketed today, still don't have that universal locking device, which I've heard about in the news. I know that the federal government has passed a regulation which says that within the next couple of years, all vehicles have to have a universal receptor, and all child seats have to have the universal locking device. But, and I believe it was the Consumer Product Safety Commission that enacted that rule, the same body that enacted the rule that say that butane lighters must be childproof. In enacting the rule, though, they didn't effect an immediate recall. They didn't immediately say you must take all existing child safety seats off the market. They found that what has to happen is a process by which the product will be made safer. So today,
Well, the question is made safer.
there's no question that that universal locking device or that the child-resistant feature makes the seat or the lighter safer.
Let me use your analogy. Suppose you have the child safety seat. And we know that every time there is either a front end or rear end accident, the newly required locking device fails and the child is injured. I think the manufacturer can say, there's no regulation, therefore I'm off the hook.
Absolutely. The manufacturer can say, I knew of that risk, in the same way that the plaintiff here or the appellant here.
Manufacturers also always say they knew of the risk. The question is whether the risk should be shared, paid for by the manufacturer, by the injured party.
That's risk utility, and our Commonwealth, again, follows the consumer expectation test. The fact of the matter is that the seller today of those child safety seats, or the seller in 1994 of this particular butane lighter, was behaving in a manner, let's assume that they both know of the potential danger. Our seller of the lighter knows that in June of this year there's going to be a requirement that it has to be childproof, but he's been told, in essence, by the setting of a date on which that regulation will become effective, that he may continue to market the product. Therefore, he has no duty. Again, folding back into Pruitt versus certainty, the question is not merely whether the risk is foreseeable, but whether a duty exists to protect against it. And we argue that where the manufacturer, or in this case the distributor or retailer of that product, is in full compliance with industry standards, the product was not defective in that it didn't malfunction. There's been a concession that this lighter worked exactly as it was intended to work. So you've delivered a product which worked as it's intended to work, is in compliance with governmental and industry standards. When that fellow was sitting in the warehouse, there was no reason for him not to continue to sell that lighter, even if he knew.
Even if he knew that people were going to be injured by it.
Because he was under the knowledge that beginning this June, that regulation will be in effect.
I'm always amazed at how industry loves to hide behind regulations when there's liability and fights regulations when it limits profit.
I was somewhat amazed when I was in Toys R Us this weekend, Judge, and I saw that those child safety seats were still there. Those parties know that that seat could cause a danger, but they're not negligent for selling it. Thank you, members of the court.
It's all consumed, but if you have a point you feel you can make with impact, in expeditious fashion, please do so.
I do, and that is that I think the issue that Judge Del Sol was so interested in that light, it's important to point out that we are here on preliminary objections. We did not get the opportunity to prove to the trial court doing a risk utility analysis
We understand. That's why
that,
you're here.
that there could be a record.
I told him he could finish. Please, do you have something you want to say?
Your Honor, no. Thank you.